Response. How did he come into custody?
Your Honor, I was in Detroit.
Okay. How'd you get into custody? Did you walk in or were you picked up?
I was picked up in Detroit.
Mr. Allen.
A case out there. And then I handled on the case. I came out here. I got discharged on probation. I have to stay in Washington County for about 7 years. So when this came in,
he was picked up originally, but I think that this second attempt at bond increase is second by him. If he was released, he's coming to court today. He's ready to.
But hold it. While he was out, basically absconding on this case, my understanding is he picked up other cases?
That's the people's understanding. While he was on probation for aggravated stalking, the judge slaves court.
Those are support cases, is that correct? Okay.
Or it might be on 14.
The initial was a failure to appear when we were before. I think I did that arraignment for him. And there were 2 months of time where he was in the hospital, if I recall, and he suffered some burns as the court made clear.
Hold on a second. Because back, just looking for a date on this, I don't know that the defendant just didn't come into court. He was incarcerated in Wayne County, January of this year. And then proceeded to send us information for a plea by mail. Requesting a trial date, review of bond with a request for dismissal due to the hearsay clause, and Washington County has no jurisdiction over me. Because he's a permanent resident of Wayne County. Yeah, go ahead.
At the arraignment, we were going back and forth with our magistrate Pink and she said, I won't quote her exactly, but the summary of it was, let him out on bond because some of it was confusion. He should be holding himself to the same standard as an attorney, but this was kind of an attempt at self-representation that went horribly wrong. And so as you can see, he's here now with an attorney. He's coming into court to address these charges, to address everything that's happening. He's not a flight risk judge. He's here now, so I would say that...
He's not a flight risk? Where was he?
He was in the hospital for 2 months, Your Honor.
When?
The court date in question, I remember it was April 1st, and he was in the hospital at that time.
Now, your assistant prosecuting attorney, Morgan Barroso, to have the people looking back at our notes, what we see is that this is a 2022 case. He was set for exam pro se on March 7th. The victim was present, willing, and cooperative. The defendant appeared on Zoom. The court, they tried to proceed with the exam at that date, but the defendant had insurmountable technical difficulties, so it was adjourned out to April 4th. And on April 4th, the defendant didn't show up.
Did not
show up. He failed to appear, and he was put in bench warrant status. After that, on the 11th of April 11th of 2024, over a year later, he's in custody in Wayne County and mails in the misdemeanor plea by mail to the court.
Correct.
So he's in bench warrant status for over a year. And obviously there's something else, other context with law enforcement going on because he's in custody in Wayne County during that time. while in bench warrant status. I'm sympathetic to him being in the hospital for a couple of months in there, but that doesn't explain the other 10 months plus where he was in bench warrant status and failed to turn himself in. At this point, I think that there's an issue with his bond being where it is and with him being out of custody, at least without having a GPS.
Well, but he didn't appear for preliminary examination.
Correct.
This lawyer informed me that I had a case with Washington County for a different reason. So at that same time, my lawyer told me to call down here, get on video camera. I was doing everything on video camera from the hospital. I saw it one time on the camera. So
It wasn't my preliminary examination.
yes, I'm just examination because I was in the hospital, so technical reasons for the computer stuff.
No. So then, after you missed the preliminary examination, what took you so long to turn yourself in? Well, you didn't turn yourself in, you got picked up.
It's like Magistrate Garwood says that all the time. I tell this to my clients. I said, look, if your cell phone bill goes out, if cable goes out, you're gonna pick up the phone, you're gonna call that and get that resolved immediately. And
I don't know if quoting Magistrate Garwood is convincing to me.
but what I'm saying is, Your Honor, I explained this to him. He wasn't represented before. He didn't understand. He tried to represent himself.
Oh, I think he understood. He understood the date. He's giving me his excuse that he's in the hospital, and then we don't see him for 10 months. And I don't know why a bond was set when we finally get to him in the amount that it's set at. In my opinion, that's a clear abuse of discretion. He didn't appear for 2 court proceedings. Well, appeared at 1. He wasn't, I don't think, supposed to be appearing via Zoom. I think Judge Perry did the best she could and then couldn't proceed with that. And then he was supposed to appear, didn't appear, and then disappears. And I think has committed other offenses, because what was he locked up in Wayne County for?
It was a obstruction of justice, and I took care of that case. I came back here, I got dismissed off of probation. Judge picked bear with me because I lost my lyrics, I lost my whole day. So I had to get my body together. And then I'll promise her that I'll come back and take care of this. But I lost my whole day, as you can see. So I have to talk.
I understand that. I'm glad it's worked for you. All I'm saying is you haven't appeared at these proceedings. You didn't turn yourself in. You got picked up, and that's the only reason that you're here. Otherwise, we would probably not be seeing you. As I've said, I think it's an abuse of discretion that this bond was set as it was. Your bond now will be $50,000 cash surety, defendant's remanded. I'll set the probable cause out. I'll just set it out since I took him into custody. I'll set it out next week, May 16th, 2024, 9 a.m.
I'm not sure.
It's what?
Good.
What about it?
Sweat that.
It's about to die?
Yes.
Did you charge it?
Yes, I was doing it today, and I came. Thought I was charging when I was sleeping, but when I came in, they said charge.
Okay. And you're telling me why I don't have a charger?
I don't know, but I was just like,
You were letting me know in case something happens
yeah.
so that we don't run out and grab you when it dies?
You want to have a record, right?
Oh, is that what this is? This is a record? Seems like premeditation to committing an offense. Go and get it charged. All right? Sit there and look at it. Make sure it's charging. All right? That's okay. I'm going to let Judge Conlon know. Or yeah, I'm going to let him know. His tether probably died. What? Bless you. All right, young man, take care. Court calls the case, People versus Vincent Lambert. Is that your mom?
My grandmother.
Your grandmother? She told you to say that, didn't she? No.
See if they had a charge, they told me to.
Yeah, I'm sure they did. Young man, if your charger's having a problem, since you're down here, stop over at Community Corrections. Don't want that thing to die on you, okay? Thank you.
This courtroom moment unfolds as a tense and revealing discussion about how the defendant actually ended up in custody, and the deeper the judge digs, the worse the situation begins to look. At first, there is confusion. The defense explains that the defendant was originally picked up, released, and later came back into court ready to face the charges. He wants dates, he wants facts, and most importantly, he wants accountability. As the timeline is slowly laid out, it becomes clear that this case stretches back years. The defendant had a preliminary examination scheduled in 2022. The victim showed up, prepared and cooperative. The defendant appeared remotely, but technical problems stopped the hearing. The court rescheduled. On the new date, the defendant simply did not appear. That failure to appear triggered a bench warrant, and from that moment on, everything spiraled downhill. The defense argues that the defendant spent 2 months hospitalized with serious injuries, including burns. The judge listens, acknowledges the hardship, and even shows sympathy. But then comes the question that changes everything. What about the other 10 months? Being in the hospital doesn't explain disappearing for nearly a year. It doesn't explain why the defendant never turned himself in. And it certainly doesn't explain why he only reappeared. Because law enforcement picked him up on other charges, the prosecution steps in and makes it clear while the defendant was in bench warrant status, he was incarcerated elsewhere dealing with additional legal trouble. This wasn't confusion. This wasn't a misunderstanding. This was a pattern of avoiding responsibility. The judge's patience starts to thin, not because of attitude, but because of choices. The defendant tries to explain himself, claiming he was confused, unrepresented, and attempting to navigate the system alone. But the judge shuts that argument down firmly. Confusion doesn't last 10 months. Confusion doesn't stop someone from picking up a phone. If people can call their cable company when service is cut off, they can call the court when a warrant is issued. Ignorance is not an excuse, especially when court dates were clearly known. At this point, the judge addresses what truly bothers him, the bond. Allowing the defendant to walk free under these circumstances, he says, was a serious abuse of discretion. The defendant missed court, didn't surrender, committed additional offenses, and only showed up because he was arrested. That's not reliability. That's not responsibility. That's risk. The ruling comes down hard. The bond is revoked. A new bond is set, $50,000 cash surety. The defendant will remain in custody. The court sets the next hearing date and makes it clear that this time there will be no excuses. Even something as small as a dying electronic tether becomes an issue, because in this courtroom, every detail matters when trust has already been broken. This case isn't about paperwork. It's about choices. It's about accountability. And it's a powerful reminder that the court system may be patient, but it never forgets. When someone ignores court orders, avoids responsibility, and only shows up when forced, the consequences are inevitable. In the end, the judge doesn't raise his voice. He doesn't need to. The facts speak louder than any argument ever could. If you believe accountability matters, hit like if you want to see more real courtroom moments where. Stay tuned, because the next case is even more intense.